Judge mocks farmer's hillbilly accent in court. The next 30 seconds make her tremble with regret. The Boone County Courthouse stood like a weathered sentinel in the center of Hartsville, Missouri, its limestone facade bearing the dignified patina of nearly a century of Midwestern seasons. Inside, Courtroom 3 maintained an atmosphere of hushed reverence, despite the failing air conditioning that left the room uncomfortably warm on this late June morning. Sunlight streamed through tall windows, illuminating dancing dust motes and casting long rectangles of light across the worn oak floor. Earl Tatum sat at the defendant's table, his weathered hands calloused from 6 decades of working the land resting awkwardly on the polished surface before him. At 61, Earl was a man whose entire being had been shaped by the rhythm of planting and harvest, his lean frame deceptively strong, his face deeply lined from years squinting against the sun. Today, those familiar elements have been replaced by the confining discomfort of his only suit, a navy blue garment purchased 20 years earlier for his daughter's wedding, now slightly too tight across his shoulders and too short at the wrists. Beside Earl sat his attorney, Daniel Mitchell, a young lawyer from the Legal Aid Rural Justice Project. Though only 4 years out of law school, Daniel had specifically chosen to focus on cases involving rural land rights. With his crisp white shirt and carefully knotted tie, he presented a stark contrast to Earl's weathered appearance. But the respect with which he leaned in to consult with his client revealed his genuine commitment to the case. Across the aisle, the plaintiff's table was occupied by 3 individuals: Richard Holloway, CEO of SunStream Energy; Patricia Evans, SunStream's corporate counsel; and James Westbrook, a local attorney retained to assist with navigating the county's legal landscape. Their matching charcoal suits and leather portfolios projected an image of corporate efficiency and unlimited resources. At the bench sat Judge Caroline Drexler, recently appointed to the circuit court after 15 years in corporate law. At 46, Judge Drexler had established a reputation for running an efficient courtroom and having little patience for what she termed unnecessary procedural delays. Her dark hair was pulled back in a severe bun, her black robe impeccably pressed, her reading glasses perched precisely on the bridge of her nose as she reviewed the documents before her. The gallery behind the bar was unusually full for a civil case, populated primarily by farmers and landowners from surrounding counties, their presence a silent show of solidarity with Earl Tatum. Word had spread quickly through the tight-knit agricultural community that SunStream Energy was attempting to use eminent domain to force Earl off land that had been his family for over a century. Case number CV 2025-0472, SunStream Energy Development versus Earl Tatum. The bailiff announced, his voice echoing in the high-ceilinged room. An action for eminent domain under Missouri Statute 523.262. Judge Drexler adjusted her glasses. This is the continuation of yesterday's hearing. Mr. Holloway, you were about to call your next witness. Richard Holloway rose smoothly. Your Honor, SunStream Energy calls Dr. Marcus Reynolds, our environmental impact assessment specialist. As a distinguished man in his 50s approached the witness stand, Earl leaned toward his attorney, whispering a question that caused Daniel to frown slightly before nodding and making a note on his legal pad. The morning proceeded with a methodical presentation of SunStream's case. The proposed solar farm represented essential infrastructure for the region's renewable energy goals. The specific location was ideal due to topography and existing power grid access. The company had offered fair market value for the property. Earl Tatum's refusal to sell was impeding progress on a project designated by the county as being in the public interest. Dr. Reynolds spoke at length about environmental benefits, job creation, and tax revenue, his polished testimony clearly rehearsed for maximum impact. Throughout, Earl sat quietly, his expression unreadable save for the occasional tightening of his jaw when particularly misleading claims were made about his property. After a brief recess, Daniel Mitchell began his cross-examination, systematically challenging SunStream's assertions regarding the necessity of using this specific parcel of land. He introduced satellite imagery showing nearby alternatives and presented evidence that the company had successfully modified project plans for other wealthy landowners while refusing to consider adjustments for Earl's property. As the questioning grew more pointed, Richard Holloway shifted uncomfortably in his seat, exchanging glances with his attorneys. Judge Drexler, who had initially appeared disinterested in the defense's arguments, began paying closer attention, occasionally making notes. "Your Honor," Daniel said, wrapping up his cross-examination, "we would like to call Mr. Earl Tatum to testify about the historical significance of the property and the viability of alternative solutions that would allow both the solar project and the preservation of his family farm." Judge Drexler nodded. "You may call your witness, Counselor." Earl rose slowly, straightening his suit jacket before making his way to the witness stand. After being sworn in, he settled himself in the chair, his large, work-roughened hands looking out of place against the polished wood of the witness box. "Mr. Tatum," Daniel began, "could you tell the court how long your family has owned the property in question?" Earl cleared his throat, his voice deep and measured when he spoke. "The original deed was signed over to my great-grandfather, Josiah Tatum, in 1887. Been in the family ever since." "And what is currently produced on this farm?" "We run about 60 head of cattle on the north section. Grow corn and soybeans in rotation on the south fields. Got about 12 acres of specialized crop heirloom tomatoes and peppers that we sell to restaurants in Kansas City." Earl's Missouri accent was pronounced, his speech pattern reflecting generations of rural tradition, dropping G's and stretching vowels in a way that marked him unmistakably as a man of the land. From the bench, Judge Drexler made a sound a short, barely suppressed laugh that nevertheless carried in the quiet courtroom. It was followed by a whispered comment to her clerk that, while inaudible to most, caused several heads in the gallery to turn in surprise. Earl paused, his eyes lifting to the judge's face. For a moment, the courtroom held its breath. Daniel Mitchell, sensing the sudden tension, quickly continued. "Mr. Tatum, could you explain why you've declined SunStream's offers to purchase your property?" Earl didn't immediately respond, his gaze still fixed on Judge Drexler, who was now studiously reviewing documents before her, seemingly oblivious to the effect of her momentary lapse in judicial decorum. "Mr. Tatum," Daniel prompted gently. Earl finally shifted his attention back to his attorney. "Yes, sorry." He straightened in his chair, his shoulders squaring almost imperceptibly. "That land isn't just dirt and grass to me. It's my heritage and my legacy. My great-grandfather cleared those fields by hand. My grandfather expanded the operation during the Depression, selling eggs door-to-door in town to keep the bank from foreclosing. My father modernized our methods, put both my sister and me through college selling cattle he'd raised with his own two hands." His voice remained steady, but those who knew him well could detect the emotion running beneath his measured words. When you've watched 4 generations pour their lives into building something, you don't just hand it over because someone offers you money. That land provides food for this community. It provides habitat for wildlife. It provides a future for my grandchildren. Daniel nodded. "Has SunStream Energy ever presented you with alternative proposals that might accommodate both your farm and their project?" "No, sir. It's been all or nothing from the start. They want my whole south section, the best cropland, or nothing at all. Offered to let me keep the house and barn, But that's it. As Earl continued to testify about the ecological uniqueness of his property, the natural springs that had never run dry, even during the drought of 2012, the ancient oak grove that served as a critical stopover for migrating birds, Judge Drexler's attention seemed to wander. Several times she checked her watch, and once she sighed audibly during a particularly detailed explanation of soil quality. When SunStream's attorney rose for cross-examination, her demeanor notably shifted, becoming more engaged and attentive. Patricia Evans approached the witness stand with a stack of documents and a practiced smile that never reached her eyes. "Mr. Tatum," she began, "you've spoken eloquently about your emotional attachment to this property, but let's discuss some objective facts. The county assessor values your entire property at approximately $1.2 million, correct? That's what they say for tax purposes, yes ma'am. And SunStream Energy has offered you $2.4 million, twice its assessed value for the portions they require. Isn't that correct?" "Yes ma'am, but..." "A simple yes will suffice," she interrupted smoothly. "Now, Mr. Tatum, you testified that this land provides food for the community. What percentage of Boone County's food supply would you estimate comes from your farm specifically?" Earl's brow furrowed. "Well, I couldn't rightly say an exact percentage. Less than 1%. Surely? I suppose that's likely, but..." "And the solar facility proposed by SunStream would provide clean energy to approximately 15,000 homes in the county. That's nearly 40% of the households in this region. Wouldn't you agree that's a significant public benefit?" Before Earl could answer, Judge Drexler interjected. "The witness will answer the question as asked, without additional commentary." Something in her tone, the faint undercurrent of condescension, caused Earl to look up sharply. Their eyes met briefly, and in that moment, he recognized something he'd seen countless times before, the dismissive judgment of someone who viewed his kind rural, plain-spoken, tied to the land as somehow less worthy of respect. Earl's jaw tightened almost imperceptibly. "With respect, Your Honor," he said, his accent suddenly more pronounced than before, "I believe I'm entitled to answer questions completely, not just in the ways that benefit the company trying to take my land." A murmur ran through the courtroom. Judge Drexler's eyebrows rose in surprise at being directly challenged. "Mr. Tatum," she said, her voice cooling several degrees. "In this courtroom, witnesses answer questions as directed by the court. Your colorful rural perspectives, while perhaps charming in other settings, do not entitle you to disregard proper procedure." The condescension in her voice was unmistakable now, drawing shocked looks from several spectators and a quick, concerned glance from Daniel Mitchell to his client. What happened next would be replayed on news programs and social media platforms across the country within hours. Earl Tatum sat perfectly still for several seconds, his weathered face betraying no emotion beyond a slight narrowing of his eyes. When he finally spoke, his voice was quiet but carried clearly through the suddenly silent courtroom. "Your Honor," he began, each word measured and deliberate, "in my 61 years, I've learned that true character ain't about how folks talk, but about how they listen. And with all due respect to this court, you haven't been listening to what's actually at stake here." Judge Drexler's face flushed. "Mr. Tatum, you are addressing a court of law, not a town hall meeting. One more outburst, and I'll hold you in contempt." Earl nodded slowly, then reached into the inside pocket of his suit jacket. "I understand, Your Honor, and I apologize if my manner of speaking doesn't meet with your approval. But before you decide I'm not worth listening to, there's something I think you should see." Daniel Mitchell tensed, clearly uncertain what his client was about to produce. SunStream's attorneys exchanged glances, while the spectators in the gallery, leaned forward collectively. From his pocket, Earl withdrew an aged, yellowed envelope, its corners soft from handling, its flaps secured with a thin red ribbon rather than adhesive. With careful movements that spoke of reverence for the document, he untied the ribbon and extracted several sheets of fragile paper covered in elegant, flowing handwriting. "Your Honor," Earl continued, "I recognize your name, Drexler. It's not common in these parts. When I learned you'd be president over this case, I remembered something my grandfather kept. A letter from a Union Army captain named Frederick Drexler, written in 1865 to my great-grandfather, Josiah Tatum." Judge Drexler's expression shifted from irritation to confusion. "This letter," Earl continued, holding it carefully, "was written by a man I believe was your great-grandfather. He wrote it after the war, when his unit had been stationed on our farm for nearly a month during the final campaigns. Would you like to know what he said?" The courtroom had gone completely still. Even SunStream's attorneys seemed captivated by this unexpected turn. Judge Drexler hesitated visibly, caught between maintaining her judicial distance and an undeniable curiosity about a family connection she'd apparently never known existed. After a moment, she gave a small nod. "You may proceed, Mr. Tatum." Briefly, Earl lifted the letter and began to read, his voice taking on a formal quality at odds with his earlier testimony. "April 18th, 1865. My dear Mr. Tatum, I write to express my profound gratitude for the hospitality shown to me and my men during our recent encampment on your land. While military necessity often requires us to commandeer resources with little regard for those who provide them, I find myself unable to depart without acknowledging the debt we owe you. In a time when many would have regarded Northern soldiers with hostility, you shared your limited provisions, allowed us access to your well when ours ran dry, and provided critical information about local terrain that undoubtedly saved lives. You did this despite knowing that our presence prevented you from planting your spring crops on time, a delay that may well bring hardship to your family in the coming winter. I have commanded men for 4 years in this terrible conflict, but it is civilians like yourself who understand that the land endures beyond our temporary battles who give me hope for reconciliation. The respect you showed us, despite our differences, despite even the uniform I wear, has taught me more about honor than any military academy. Please accept the enclosed sum, not as payment for your aid, which cannot be valued in mere dollars, but as a token of the esteem in which you are held by myself and my men. Should you ever travel to Boston after this war has ended, you would find a warm welcome at my family home. With deepest respect, Captain Frederick Drexler, 3rd Massachusetts Cavalry. As Earl finished reading, he carefully refolded the letter along its well-worn creases. The silence in the courtroom was absolute, broken only by the faint sound of the struggling air conditioning system. "This letter," Earl said, his eyes meeting Judge Drexler's directly, "has been passed down through my family for generations as a reminder that respect transcends differences in background, education, or manner of speech." Captain Drexler recognized the value of our land and our way of life, even though he came from a world very different from ours. He placed the letter gently on the witness stand before him. "I don't know if you're directly related to the man who wrote these words, Your Honor, but I do know that when you laughed at the way I speak, yes. I heard it plain as day you weren't upholding the principles of respect and fairness that this very courtroom is supposed to represent." Judge Drexler's face had lost all color. She opened her mouth to speak, then closed it again, visibly struggling to maintain her judicial composure. In the gallery, someone had surreptitiously recorded Earl's reading of the letter on their phone. Within minutes, the video would begin its journey across social media platforms, setting in motion events that no one in the courtroom could have anticipated. Daniel Mitchell, recognizing both the power and the risk of the moment, quickly rose. "Your Honor, we would like to enter this historical document into evidence as Exhibit 37, relevant to the historical significance of the property and the Tatum family's long-standing stewardship of the land in question." This procedural request seemed to snap Judge Drexler back to the present moment. "Yes, of course. The letter will be entered into evidence." She cleared her throat. "I think this would be an appropriate time for a recess. Court will resume in 30 minutes. As she rose to leave the bench, her eyes briefly met Earl's again. This time, there was no condescension in her gaze, only a complex mixture of embarrassment, surprise, and something that might have been respect. By the time court reconvened 30 minutes later, the video of Earl Tatum reading Captain Drexler's letter had already been viewed over 50,000 times. News vans from stations in Kansas City and St. Louis were setting up in the courthouse parking lot, and Farmer Earl was trending on multiple social media platforms. Inside the courtroom, the atmosphere had shifted palpably. Judge Drexler returned to the bench with a noticeably different demeanor, more subdued, her earlier impatience replaced by a careful attention to procedural fairness. The SunStream attorneys huddled in whispered consultation, clearly unsettled by the turn of events. "Before we continue," Judge Drexler began, her voice carefully neutral, "I wish to address a matter of courtroom decorum. It has been brought to my attention that my reaction to Mr. Tatum's manner of speech earlier may have been perceived as disrespectful." She paused, visibly choosing her next words. "The dignity of these proceedings requires mutual respect from all participants, including the bench. If my conduct fell short of that standard, I offer my apology to Mr. Tatum and to this court." A murmur of surprise rippled through the gallery. Judicial apologies were rare enough to be noteworthy in any circumstance, but particularly in the middle of ongoing proceedings. Earl, who had returned to his seat beside Daniel Mitchell, acknowledged the apology with a slight nod. His expression remained composed, revealing neither triumph nor lingering resentment. "We will now continue with SunStream Energy's cross-examination of Mr. Tatum," Judge Drexler continued. "Ms. Evans, you may proceed." Patricia Evans approached the witness stand with noticeably less confidence than before. The corporate attorney had clearly reassessed her strategy in light of the judge's changed demeanor and the unexpected revelation of the historical letter. "Mr. Tatum," she began, "I'd like to return to the question of public benefit. Do you acknowledge that renewable energy infrastructure serves an important public purpose?" "Yes, ma'am, I do," Earl replied. "I've got solar panels on my own barn roof. Put them up 3 years ago. I believe in clean energy. What I don't believe in is taking prime farmland out of production when there are alternatives." "What alternatives would those be, specifically?" Earl leaned forward slightly. "SunStream owns 300 acres of former strip mine land, just 8 miles east of my property. It's already been disturbed, has minimal agricultural value, and is closer to existing transmission lines. I've suggested that location repeatedly, but your client insists it would cost more to develop." Evans blinked, clearly not expecting such a specific answer. "That property has topographical challenges that would increase construction costs significantly. By about 15%, according to SunStream's own feasibility study," Earl countered. "I requested those documents during discovery. Seems to me that's a reasonable cost to avoid destroying century-old farmland." As the cross-examination continued, it became increasingly clear that Earl Tatum was far more prepared and knowledgeable than the SunStream team had anticipated. His plain speech and weathered appearance had led them to underestimate both his intelligence and his determination, the same mistake Judge Drexler had initially made. By mid-afternoon, the complexion of the case had shifted dramatically. What had begun as a seemingly routine eminent domain proceeding had transformed into a highly publicized battle over land rights, corporate responsibility, and the often overlooked value of agricultural heritage. Outside the courthouse, the crowd had grown to several hundred people. Farmers had arrived from neighboring counties, many driving tractors that now lined the street in a show of solidarity. Local businesses had begun displaying hastily made signs declaring, "We stand with Earl," and "Farmers Feed America." Inside, Daniel Mitchell called his final witness, Dr. Eleanor Winters, an agricultural economist from the State University. With methodical precision, Dr. Winters laid out the economic, environmental, and food security implications of converting prime farmland to non-agricultural uses. Once farmland of this quality is taken out of production, it is effectively lost forever, she testified. Even if the solar panels were removed decades from now, the soil structure and fertility would be severely compromised. From a long-term food security perspective, this represents a permanent loss to our productive capacity. As the day's proceedings drew to a close, Judge Drexler addressed both legal teams. In light of the significant public interest in this case and the complex issues raised today, I am taking this matter under advisement. I will issue my ruling next Monday at 9 a.m. Court is adjourned. As people began filing out of the courtroom, a court officer approached Earl with an unexpected message. Judge Drexler had requested to speak with him privately in her chambers. Daniel Mitchell immediately objected to his client meeting with the judge without counsel present. "It's all right, Daniel," Earl assured him. "I'd like to hear what she has to say." "Then I'm coming with you," the young attorney insisted, his protective instinct toward his client overriding protocol concerns. In the judge's chambers, a wood-paneled room with law books lining the walls and framed credentials displaying her academic and professional achievements, Caroline Drexler sat behind her desk, her judicial robe now hanging on a nearby rack. "Mr. Tatum, Mr. Mitchell," she greeted them, gesturing to the chairs opposite her desk. "Thank you for agreeing to this unorthodox meeting. I want to assure you that nothing we discuss here will influence my ruling on the case, which will be based solely on the legal arguments and evidence presented in court." Earl nodded, waiting for her to continue. "I wanted to speak to you about the letter," she said, her formal tone softening slightly. "Captain Frederick Drexler was indeed my great-grandfather. I knew he had served in Missouri during the Civil War, but I had no knowledge of his interaction with your family or this letter's existence. Family histories often get lost in the shuffle of modern life," Earl replied without judgment. "My grandfather made sure I knew about Captain Drexler, though. Said he was a man who could see past differences to find common ground." Judge Drexler's professional composure slipped momentarily, revealing a glimpse of personal emotion. "May I ask, the sum he enclosed with the letter? What was it used for?" Earl's weathered face broke into its first genuine smile of the day. "According to family lore, it bought the seed for that year's planting. My great-grandfather always said that without Captain Drexler's help, we might have lost the farm during the hard years after the war." He paused thoughtfully. "In a way, your family helped ensure that mine could keep working that land for generations to come." The irony of this historical connection, that a Drexler had once helped save the very farm now at risk in her courtroom, was not lost on anyone present. "I appreciate you sharing that history," the judge said finally. "Whatever my ruling on Monday, I want you to know that I've heard you, truly heard you, about what this land means to your family." As Earl and Daniel left the chambers, they found the courthouse corridors still bustling with activity despite the late hour. News crews were setting up for evening broadcasts, and a group of farmers waited patiently to speak with Earl. "What happens now?" Earl asked his attorney quietly. Daniel's expression was cautiously optimistic. Now we wait. But something important happened in that courtroom today, something that goes beyond the legal arguments. You made people see the human cost of these decisions, not just the judge, but everyone watching. That matters. Earl nodded slowly, suddenly looking very tired. The emotional toll of the day's events had finally caught up with him. Think I'll head home now. Got cows to feed. Life doesn't stop for court cases. As he made his way through the crowd, accepting handshakes and words of support with humble gratitude, Earl remained unaware that his quiet dignity in the face of disrespect had already transformed him into something he never sought to be, a symbol of resistance against the casual dismissal of rural America's values and contributions. By Friday morning, what had begun as a local land dispute had exploded into a national conversation. The video of Earl reading the historical letter had been viewed millions of times, spawning countless reaction videos, opinion pieces, and heated debates about judicial conduct, land rights, and class bias in the legal system. On the steps of the Boone County Courthouse, a group of protesters gathered with signs ranging from "Save Our Farms" to "Judges Should Listen," "Not Laugh," and "Solar Yes, Land Theft No." News crews from national networks had joined the local stations, turning the small-town courthouse into the epicenter of a much broader cultural conversation. Inside his farmhouse, Earl sat at his kitchen table, overwhelmed by the sudden attention. His ancient farmhouse phone had rung so constantly that he'd taken off the hook. His daughter had been fielding calls on her cell phone from everyone from distant relatives to national talk shows requesting interviews. "Dad, you need to see this," she said, placing her laptop in front of him. On the screen was a petition with over 70,000 signatures calling for Judge Drexler to recuse herself from the case due to demonstrated bias. Earl frowned, shaking his head. "That's not right. The judge apologized proper, and that should be the end of it. I don't want to be part of a pile-on against her." "But Dad, what she did was wrong. People are just standing up for you." "Most of those people don't know me or the judge," Earl replied firmly. "They saw a 30-second video and think they understand everything about a complicated situation. That's not how I want this to go." Before his daughter could respond, Earl's cell phone, used primarily for emergencies and rarely carried, buzzed with a text message. It was from Daniel Mitchell. "Need to meet ASAP. Important development. Can I come to the farm?" An hour later, Daniel's car pulled up the long gravel driveway to the Tatum farmhouse. The young attorney looked both excited and concerned as Earl welcomed him onto the wide front porch where generations of Tatums had watched sunsets over their fields. "SunStream has made a new offer," Daniel announced without preamble. "They're willing to completely reconfigure their project to use only the non-agricultural portions of your property, primarily the rocky northern section near the county road. They'd lease it for 30 years rather than purchase it outright, and they'd increase their payment by 20% over the previous offer." Earl's eyebrows rose in surprise. Sounds like they're suddenly mighty flexible after claiming it had to be all or nothing. "The publicity has them rattled," Daniel acknowledged. "Their corporate headquarters has been flooded with calls. Their stock price took a hit yesterday, and they're facing protests at project sites in 3 other states. They want this to go away." Earl considered this, looking out over the south fields where the corn was just beginning to tassel. "What do you think as my lawyer?" Daniel chose his words carefully. "Legally, it's a much better offer. It preserves your primary agricultural operations while still providing substantial income. From a purely practical standpoint, it's a win." "But," Earl prompted, hearing the hesitation in the young man's voice. "But this isn't just about your case anymore," Daniel admitted. "Your stand has become a rallying point for rural communities feeling steamrolled by corporate interests. If you settle privately, some will see it as undercutting the larger cause. Earl's weathered face revealed his discomfort with this assessment. "I never asked to be a symbol of anything. I'm just trying to keep my family's land." "I know, and your first responsibility is to your own family and farm," Daniel assured him. "I'll support whatever decision you make." Before Earl could respond, the sound of approaching vehicles drew their attention. Coming up the driveway was a convoy of cars led by a sleek black SUV with tinted windows. "Were you expecting more company?" Daniel asked, concerned. Earl shook his head, rising from his chair as the vehicles parked and their occupants emerged. From the lead SUV stepped Richard Holloway, SunStream CEO, accompanied by Patricia Evans. From the other vehicles came a film crew and several individuals with the polished appearance of corporate executives. "Mr. Tatum," Holloway called out, approaching the porch with his hand extended. "I hope we're not intruding. I felt it was important to discuss our new proposal in person." Earl regarded the CEO warily, making no move to invite them inside. "My lawyer already told me about your offer." "Yes, but I wanted to explain personally how committed SunStream is to finding a solution that works for everyone," Holloway replied smoothly. He gestured to the film crew. "We've also brought our media team to document this positive development, a true win-win situation that demonstrates how clean energy and traditional agriculture can coexist." Daniel stepped forward. "Mr. Holloway, any negotiations should go through counsel, and filming on private property without prior permission is inappropriate." Holloway's smile tightened slightly. "Of course, you're absolutely right. We're just excited about the possibility of resolving this unfortunate situation in a way that benefits everyone." Mr. Tatum becomes a clean energy partner while preserving his farming heritage, and SunStream gets to move forward with a project that will bring renewable energy to the community. The calculated PR strategy was transparent. SunStream wanted to transform the narrative from heartless corporation versus sympathetic farmer to innovative partnership between business and agriculture. With cameras rolling, they hoped to capture a handshake moment that would instantly defuse the negative publicity they'd been facing. Earl's expression remained impassive as he considered the man before him. After a long moment, he spoke quietly. "Mr. Holloway, I've lived on this land my entire life. In that time, I've learned that trust, like topsoil, takes years to build and moments to destroy. You spent months telling courts and county commissioners that there was absolutely no way to modify your project. Now suddenly, when the public spotlight turns your way, you find flexibility you claimed didn't exist." He gestured to the waiting film crew. "And you bring cameras to my home without asking, hoping to get footage you can use to make yourselves look good. That tells me everything I need to know about how SunStream operates." Holloway's affable expression hardened. "Mr. Tatum, I'm trying to offer you a reasonable compromise. Don't let pride or sudden celebrity status cloud your judgment. It's not pride, Mr. Holloway. It's principle." Earl's voice remained steady, but there was steel beneath the surface. "If your company was willing to lie about something as basic as project design options, what else are you lying about? The environmental impacts? The job creation numbers? The tax benefits to the county?" Patricia Evans stepped forward, her legal training asserting itself. "Mr. Tatum, those are serious allegations that could be considered defamatory. I suggest you consider your words carefully." Daniel Mitchell moved protectively closer to his client. "Ms. Evans, I suggest your team leave now. Any further communication should be conducted through proper legal channels." For a tense moment, it seemed Holloway might argue further. Instead, he reached into his jacket pocket and withdrew a business card, placing it deliberately on the porch railing. "Our offer expires at noon on Sunday, Mr. Tatum. After that, we returned to court Monday morning, and regardless of Judge Drexler's ruling, we're prepared to appeal all the way to the state Supreme Court if necessary. Ask yourself if you have the resources for that kind of extended legal battle. With that parting threat, he turned and walked back to his waiting SUV, the disappointed film crew and other executives following. As the vehicles disappeared down the driveway, Earl released a slow breath. Well, that answers one question, which is, Daniel asked, whether I can trust anything they say. Earl's expression was resigned but determined. Let's go back to court on Monday and let the judge make her ruling based on law, not pressure tactics. What neither man knew was that the confrontation had not gone entirely unrecorded. A neighboring farmer, who had come to deliver a show of support, had witnessed the exchange from his truck parked near the property line. His cell phone video of SunStream's attempted PR ambush would be online within hours, adding yet another dimension to the unfolding drama. The weekend passed in a blur of preparation. Earl spent Saturday morning with Daniel, reviewing his testimony and the key points they wanted to emphasize in their final arguments. The afternoon was devoted to farm work. Certain tasks couldn't be postponed, regardless of legal battles, and Sunday was spent with family, sharing a meal and attempting to maintain some normalcy amidst the storm of attention. By Sunday evening, the neighbor's video of SunStream's confrontation at the farm had been viewed hundreds of thousands of times, further shifting public sentiment in Earl's favor. The company's attempt to stage a PR victory had backfired spectacularly, revealing a calculated inauthenticity that contrasted sharply with Earl's straightforward dignity. Meanwhile, in her home office across town, Judge Caroline Drexler was putting the finishing touches on her written opinion. The legal questions were complex, touching on property rights, the proper application of eminent domain, and the balance between economic development and agricultural preservation. But beyond the legal analysis, she found herself reflecting on the deeper implications of the case about whose voices were valued in the halls of power, about the assumptions she'd made based on Earl Tatum's appearance and speech patterns. The letter from her great-grandfather sat on her desk, not the original, which remained with the court clerk as evidence, but a photocopy she'd made for herself. Its elegant 19th-century script reminded her of connections and responsibilities that transcended the immediate case before her court. Monday morning arrived with a crystalline autumn sky, the kind of perfect Midwestern day that farmers like Earl Tatum treasured for harvest. The courthouse square was packed by 8 a.m., with supporters from across the agricultural community standing shoulder to shoulder with environmental activists who opposed corporate land grabs, an unlikely alliance united by Earl's stand against SunStream. Inside the courtroom, every seat was filled. National media representatives jostled for position in the designated press area, while Earl sat quietly at the defense table, his Sunday suit freshly pressed, his posture betraying no hint of the enormous pressure he faced. At precisely 9 a.m., the bailiff called the court to order, and Judge Drexler entered, her expression revealing nothing of her decision. She took her seat and surveyed the packed courtroom with a measured gaze. "Before I deliver my ruling in this matter," she began, "I would like to address certain procedural issues that arose during these proceedings." The room fell completely silent, all eyes fixed on the judge. It has been suggested by many outside this courtroom that I should recuse myself due to the incident that occurred during Mr. Tatum's testimony. I have given this suggestion serious consideration. She paused, her gaze briefly meeting Earl's across the courtroom. Recusal is appropriate when a judge's impartiality might reasonably be questioned. In this case, however, I believe that recusing myself would actually constitute an abdication of responsibility. It would allow me to avoid confronting my own behavior and its implications, which would be a disservice to this court and to the principles of justice it represents. Murmurs spread through the gallery as people realized they were witnessing something extraordinary, a judge publicly acknowledging a failing and refusing to take the easy path of stepping aside. Instead, Judge Drexler continued, "I have chosen to directly address my conduct, learn from it, and ensure that my ruling is based solely on the law and evidence which, I might add, was substantially illuminated by Mr. Tatum's testimony, regardless of the manner in which it was delivered." She lifted a substantial document from the bench before her. "I have prepared a written opinion that details my analysis of the legal issues in this case. It will be entered into the record and made available to all parties. For now, I will summarize my ruling." The tension in the courtroom was palpable as attorneys from both sides leaned forward attentively. The question before this court is whether SunStream Energy's attempt to use eminent domain for their solar project constitutes a public use that justifies the taking of private property, particularly agricultural land with historical significance. Judge Drexler adjusted her glasses and continued. Missouri law, specifically statute 523.262, prohibits the use of eminent domain for solely economic development purposes. SunStream has argued that their project transcends mere economic development because it provides clean energy infrastructure, which they classify as an essential public utility. She paused, turning a page in her opinion. While I agree that renewable energy infrastructure serves a legitimate public purpose, that fact alone does not automatically justify the taking of any specific parcel of land. The condemning authority must demonstrate not only that the project serves a public purpose, but that the particular property in question is necessary to that purpose, and that alternatives have been adequately considered. Earl remained perfectly still, his weathered hands clasped on the table before him. Based on the evidence presented, including SunStream's own feasibility studies, I find that the company has failed to demonstrate that Mr. Tatum's property is uniquely necessary for their project. Alternative locations exist that would achieve substantially similar results without requiring the conversion of century-old agricultural land. A wave of whispered reactions swept through the courtroom as people began to realize which way the ruling was going. Furthermore, Judge Drexler continued, I find particularly compelling the expert testimony regarding the irreversible nature of converting prime agricultural soil to non-agricultural uses. Once such conversion occurs, the land's ability to produce food is effectively terminated for decades, if not permanently. In an era of increasing concerns about food security and agricultural sustainability, such permanent conversion of prime farmland must be subject to the strictest scrutiny. She looked up from her document, addressing the courtroom directly. Therefore, I rule in favor of the defendant, Earl Tatum. SunStream Energy's petition to exercise eminent domain over the Tatum property is denied. The courtroom erupted in cheers and applause, forcing the bailiff to call repeatedly for order. Earl remained seated, his expression one of quiet relief rather than triumph. Across the aisle, the SunStream legal team huddled immediately in tense consultation. Judge Drexler raised her hand for silence. I have one final comment before we adjourn. This case has attracted unusual public attention, much of it focused on a momentary lapse in judicial decorum for which I have already apologized. That incident, regrettable as it was, has overshadowed the substantive issues at stake, issues about land use, about whose voices are heard in our legal system, and about how we balance progress with preservation. Her voice took on a reflective quality that few in the courtroom had heard before. The legal profession often prizes precision of language and formal education. Those are valuable qualities, but they are not the only forms of knowledge or expression that matter. As this case has reminded us, wisdom comes in many accents, and expertise isn't always accompanied by credentials. With that philosophical coda, she concluded the proceedings. This court is adjourned. As people began to file out, many stopping to congratulate Earl, Patricia Evans approached the defense table. Her corporate demeanor had softened somewhat, replaced by what appeared to be genuine professional respect. "Mr. Tatum," she said, extending her hand. "SunStream will be reviewing its options regarding appeal, of course, but I want to tell you personally that you presented your case with exceptional dignity. Whatever happens next, you've earned my respect." Earl stood and accepted her handshake. "Thank you, Ms. Evans. I appreciate that." Outside the courthouse, the scene resembled an impromptu festival. Farmers who had driven their tractors to town in solidarity honked their horns in celebration. Local business owners who had supported Earl handed out free coffee and pastries. News crews scrambled for position, hoping to capture Earl's first comments after the victory. Daniel Mitchell fielded most of the media requests, allowing Earl a moment of quiet reflection on the courthouse steps. It was there that Judge Drexler, having exited through a side door and changed out of her judicial robe, approached him. "Mr. Tatum," she said quietly, "I wanted to thank you." Earl looked at her with surprise. "Thank me, Your Honor? For what? For teaching me something important?" She hesitated, choosing her words carefully. "I've spent my career in environments where people who speak like me, who were educated like me, are automatically assumed to be the smartest people in the room. It becomes easy to confuse manner of expression with substance of thought." Earl nodded, understanding exactly what she meant. "Easy habit to fall into, I suppose. We all have our blind spots. The difference is that my blind spots, from the position I hold, can cause real harm," she acknowledged. "Your willingness to stand your ground with dignity, to correct me without contempt. It was a masterclass in true judicial temperament, ironically enough." They stood in silence for a moment. An unlikely connection formed across vastly different lives. "I've been thinking about my great-grandfather's letter," Judge Drexler said finally, "about how he recognized something in your great-grandfather that transcended their differences. I believe you would be proud to know that his words still mattered, more than a century and a half later." "History has a way of coming full circle sometimes," Earl agreed. "Captain Drexler helped save our farm after the Civil War. Maybe, in a way, he helped save it again today through you." The judge smiled at this sentiment. "I like to think so." She extended her hand, which Earl shook warmly. "Good luck with your harvest, Mr. Tatum." "Thank you, Your Honor. Good luck with your cases." As Judge Drexler walked away, Daniel Mitchell approached with news that multiple national morning shows wanted to interview Earl the following day. "Not interested," Earl said immediately. "Got corn to harvest. Weather's perfect right now, and that doesn't wait for TV appearances." Daniel laughed. "Somehow I knew you'd say that. But there is one request you might want to consider. The law school at the state university has asked if you'd be willing to speak to their students about the case. Not right away, maybe after harvest." Earl raised an eyebrow. "What could I possibly teach law students?" "More than you realize," Daniel replied. "Sometimes the most important legal lessons have nothing to do with statutes and precedents. They're about humanity, dignity, and standing your ground even when the system seems stacked against you." Earl considered this. "Well, if they think an old farmer with dirt under his fingernails has something worth saying, I suppose I could make time after the fields are clear." 6 months later, Earl Tatum stood at a podium in the main lecture hall of the State University Law School, addressing a room packed with students, faculty, and community members. The Tatum case, as it had come to be known, had become a staple in legal ethics classes and property law seminars across the country. I never set out to make legal history, Earl began, his Missouri accent unchanged despite his now frequent speaking engagements. I just wanted to keep farming the land my family has worked for generations. From the back of the hall, he could see Daniel Mitchell watching with pride. In the months since the ruling, the young attorney's career had flourished. The Legal Aid Rural Justice Project had expanded, with new funding and a growing roster of attorneys committed to representing agricultural communities in legal disputes. What I learned through this process, Earl continued, is that systems, even good ones like our legal system, develop blind spots. They start valuing certain kinds of knowledge over others, certain ways of speaking over others, certain backgrounds over others. Not out of malice, usually, but out of habit and convenience. In the front row, to Earl's surprise, sat Judge Caroline Drexler. She had requested permission to attend without fanfare, genuinely interested in hearing Earl's perspective on their shared experience. The remedy for these blind spots isn't anger or resentment, Earl said. It's persistence, showing up and speaking your truth, especially when it's uncomfortable. Standing your ground without losing your dignity, and recognizing that sometimes the most powerful thing you can do is simply refuse to be dismissed. The Tatum case had indeed sparked changes beyond Earl's farm. The state legislature was now considering a bill specifically protecting agricultural land from certain eminent domain actions. SunStream Energy, after deciding against an appeal, had redesigned their project for the alternative location Earl had suggested all along the former strip mine land east of his property. Most significantly, a judicial conduct initiative had been launched, focused on identifying and addressing implicit biases in the courtroom. Judge Drexler, in a move that surprised many, had become one of its strongest advocates, sharing her experience as a cautionary tale for other judges. After the formal presentation, as students and faculty gathered around Earl with questions, Judge Drexler approached him quietly. "That was quite a lecture, Mr. Tatum. You're a natural teacher." Earl smiled. "Not sure about that, but I've had a lifetime of practice explaining complex things simply. That's farming for you, complicated work that doesn't allow for complicated language." "I have some news you might find interesting," she said. "The Historical Society has authenticated your letter from Captain Drexler. They've asked if they could create an exhibit featuring it, along with artifacts from both our families. A kind of testament to how connection can transcend conflict." "I'd be honored," Earl replied, "though I'll need the letter back eventually. It belongs in the family archive for future generations." As they discussed the details, a law student approached cautiously, clearly intimidated by interrupting a conversation with a judge. "Excuse me, Mr. Tatum. I just wanted to say thank you. I'm from a small farming community in western Kansas, and I've spent my first year of law school trying to hide my accent and background. Your case, it helped me realize I don't have to become someone else to belong here." Earl's weathered face softened. "What's your name, son?" "Jason Reynolds, sir." "Well, Jason, remember this. Where you're from and how you speak is part of what you bring to this profession. Don't let anyone tell you it's a liability. It's a perspective others might not have, and that's valuable." After the young man walked away, Judge Drexler shook her head in amazement. "You've started something much bigger than a legal case, Mr. Tatum." "Maybe," Earl acknowledged modestly. "Or maybe I just reminded folks of something they already knew but had forgotten. That worth isn't measured by credentials or vocabulary, but by character and conviction." 1 year to the day after Judge Drexler's ruling, a small ceremony was held in the Boone County Courthouse. A simple bronze plaque was unveiled in the main corridor, bearing an image of the historic letter and an inscription that read, "In honor of the Drexler-Tatum correspondence, 1865 to 2025, reminding us that respect transcends difference, that justice depends on truly hearing all voices, and that our common humanity outlasts our temporary disagreements. Earl, true to his nature, had initially resisted the idea of a permanent marker. "Seems unnecessary," he protested. "I didn't do anything special." But Daniel Mitchell had convinced him otherwise. "It's not just about you, Earl. It's about what your stand represented to others. Sometimes people need symbols to help them remember important principles." Now, as Earl ran his fingers over the cool bronze of the plaque, he had to admit there was something fitting about the courthouse itself bearing a permanent reminder of the case. Not because he had won, though, that mattered deeply for his family's future, but because something fundamental had been acknowledged about whose voices deserved to be heard. Judge Drexler, standing beside him at the small gathering, seemed to read his thoughts. "Your great-grandfather would be proud," she said quietly. "Not just of the outcome, but of how you conducted yourself throughout." Earl nodded, thinking not of courtrooms and legal victories, but the quiet satisfaction of the harvest he'd just completed, the best yield in years from fields that remained in his family's care, as they had for generations and would for generations to come. "It's good soil," he said simply, a statement that contained within it everything that had been at stake. "Worth standing up for." As he left the courthouse that day, declining invitations to a celebratory lunch in favor of returning to the endless work of the farm, Earl remained unchanged by his brush with fame. His pickup truck still had mud on the wheel wells from morning chores. His hands still bore the calluses of daily labor. His accent still carried the rhythms of rural Missouri. What had changed was something less visible but more significant. Whenever he spoke now, people listened not with the condescension or impatience often directed toward those from rural America, but with genuine attention and respect. Not because he had become someone different, but because he had refused to be anything other than exactly who he was. And in that simple, stubborn authenticity lay a lesson more powerful than any legal precedent. That dignity is not bestowed by authority, but claimed through conviction. That respect is not granted by position, but earned through character. And that sometimes the quietest voices carry the most profound truths. Back on his land, as evening settled over fields that stretched to the horizon, Earl stood on the porch where generations of his family had watched the same sunset. The legal battle was behind him now, preserved in law books and courthouse plaques. But the land remained, as it always had, the true constant in the Tatum family story, a legacy of stewardship passed from hand to hand across centuries. From his pocket, Earl withdrew the letter that had changed everything, its fragile pages now carefully preserved in an archival sleeve. In the fading light, Captain Frederick Drexler's elegant script was barely visible, but the words had become familiar enough that Earl no longer needed to read them to remember their message. "The respect you showed us, despite our differences, despite even the uniform I wear, has taught me more about honor than any military academy." A century and a half later, those words had resonated in another Drexler's courtroom, creating a bridge across time that had saved this land once again. Earl carefully returned the letter to his pocket, a tangible reminder that sometimes the most powerful weapon against injustice is not anger or outrage, but the quiet, unwavering insistence on being seen and heard for who you truly are. As darkness fell over the Tatum farm, Earl turned toward the house, toward the light spilling from windows that had welcomed his family home for generations. The court case that had briefly made him a reluctant symbol would eventually fade from public memory. But the land would remain, and with it, the simple truth he had defended, that some things, once lost, can never be replaced, and are therefore worth fighting for with everything you have. And that, in the end, was a legacy worth passing on not in courtrooms or on courthouse plaques, but in the enduring connection between people and the land that sustains them, a relationship that transcends legal documents and judicial rulings to touch something fundamental about who we are and what we value most.